Good afternoon, everyone. Welcome to our meeting. Can you guys hear me okay?
Yes, good afternoon, Orlando.
Yes, Maurice, how you doing?
Fine, thank you.
Very good, very good.
How about your birthday?
Oh man, it was amazing. It was amazing. It was very good. I was celebrating 3 days in a row with different people. It was good. It was good. I had a lot of fun. I had a lot of cries also, you know. My stepson gave me a card, and he's been my stepson for 2 years only. And it was such a beautiful card. Not gonna believe it. I already read that part 20 times, and every time I can't stop the tears come from my eyes.
That's nice.
Yeah, it was good. Thank you. Thank you for asking. All right, guys, I hope you are all doing great. I do have some background noise, and I hope it's not going to bother you guys from or keeping you guys from hearing me. I even put a music here to see if we block the noise. So we are excited today. We have a very good subjects that we're going to talk about it. And one of them is going to be brought by our friend Scott. Just a reminder, Scott has been a very good friend of mine for many years. Scott is a criminal attorney. And when he heard that we opened our new company, he decided to join us, which was an honor to me. And he also offered his service as an in-house counsel, general counsel, for any legal or matters not related to real estate, of course, because that's for John. And there's one subject that a lot of people has been asking about it, has been going through some problems with the developers because they do use their own contract. We don't write our contract or AZ's contract or a standard contract. They use their own contract. And sometimes, and I don't want to say, but most of the time, it's very complicated to deal with the developers. And Scott has been through a huge experience because Scott is buying one apartment from a developer, and he's willing to share with us this experience, which I believe it's going to be very knowledgeable for all of us in the future when you work with the buyer purchasing a new development unit. You will be able to be more prepared to deal with them. Scott, our meeting, I'm gonna start with you. How you doing,
Okay.
Scott?
I thank you for that intro, Orlando. Very generous and kind of you, and the honor is really mine to be part of this group. You and I have always clicked since day one, and when you branched off and did this, I knew I wanted to be a part of it. So thank you for having me. Having said that, Orlando is correct. Recently, my wife and I decided that we wanted to buy a unit, and we're located in the Brickell area. So we knew after several moves, that's where we wanted to be. And so we started looking at all of the buildings. We had lived in Rise, which was part of Brickell City Center. We then moved to a larger space in Brickell Heights, which was a block or two away. But in the end, we focused on a building that was a new building. It was called Flatiron. And it was a development that was done by Ugo Colombo of the CMC Group. He also owns the Collection, and he's known for doing very high-end stuff. And my wife, Anna, who's also now a real estate specialist and agent and with us here at One Way, as well as my legal assistant, Jennifer, who passed the exam and has now joined us. So I welcome both of them. But with Anna and I deciding on the Flatiron, I then engaged their realtor, and they have basically several in-house realtors that they use to sell whatever units are still owned by the developer. And so the first thing I did was a little bit of homework to find out about that realtor, because I think you always want to know who you're dealing with. And the feedback I got was that she was very aggressive, keep your eye on her, be very careful about what you do because, you know, she was a pit bull. So with that, I also did some homework on the developer, which I think you'll always want to do if your client is looking to buy from a developer. And as Arlindo said, the first thing I encountered was that they produced the contract. So if you think you're going to go in there with your client and then hand them a contract, it won't work. They have their own contract, and so be it. They're non-flexible. You will have to use theirs. This particular contract, I think, was 15 pages with a lot of fine print, and I had 2 people helping me because I don't specialize in real estate law. I've done a number of purchases and sales for myself. And so I enlisted the help of John, who you all know by now, as well as my brother, Michael, who is a 30+ year real estate attorney. And he represents banks, developers. So he's got a lot of experience with this. So I had them on my team, so to speak. And the developer was represented by the largest law firm down here, just about, Greenberg Traurig. So the first thing I encountered, and I'm going to ask Jennifer to throw up a presentation that she helped me put together, and I'll sort of walk you through it, and I'll try to do it quickly. Can you get that up, Jen?
Hi, Arlindo, can you allow me to share the screen?
Arlindo.
You're mute.
Okay, Jennifer, I'm going to make you a host and you can share the screen, okay?
Thank you, Arlindo.
You're welcome. All right, Jennifer, you're the host. You can share your screen now.
While she's getting that up, you're going to see that the first thing I had to encounter was basic contract law. Any of us helping a client buy or sell, it's pretty straightforward. You have your contract. In this case, me as the buyer, I would sign the contract. I would then send it to the seller, expecting him to sign it. And essentially what happened was they said, well, you need to put down a deposit with your signature. And my position was, I'll put down a deposit once I have an executed contract. Well, they don't work that way. They won't even look at your signature unless you put a deposit with it. And in addition to the deposit, they want 10%. Now, I don't know if other developers will require that same amount, but my typical experience is, as John has told you in the past, you want as small a deposit as possible, 2%, 5%. 10% is the absolute highest, and that's exactly what they're demanding. And they're not flexible on it. So they essentially expect you to sign a contract and put down a large deposit, and then they're going to decide if they're going to sign and accept it, even though you've verbally talked back and forth. Now, the whole process of arriving at a price took months, and it was quite complicated. But in the end, quite frankly, we beat them up pretty good, and we got them down over $100,000 off of their list price. And so once we knew we had an agreed number is when this whole contract thing started. So on the one hand, lawyers are going to tell you certain things, such as, no, you cannot wire them $30,000 or $60,000 or $90,000 without them signing the contract. But what you're going to learn is, and this is what you need to tell your client, the advice I'm giving you is wait till you have the contract before you make the deposit. But if you're dealing with the developer, your deal ends there if you're going to stand on that. So you as an agent basically have to give your client the option and explain to them, this is what you should be doing. I'm telling you to do it this way, but as you're seeing, they won't do it that way. This way, if something goes south, you at least gave your client the right advice. And I would say send them an email saying, look, this is the way it should be done, but this is what they want to do. I'm not advising to do it this way, but this is how you would have to do it if you're going to move on with this contract. And so I had to break from protocol. I had to break from everyday common contract law and sign that contract and send them a deposit to keep this deal moving. So once that was done, then they've got you because they have your money. And that's when I'd be contacting the realtor saying, okay, where is the signed executed contract? And I kept on getting stalled. Okay, you'll have it in 48 hours. 48 hours would come and I'd have nothing. Now, there's reasons why you need to get their signature on there and you need to get it quickly. And that is they're counting the time that that contract is in effect from when you sign it. So, for example, there was a number of issues that were real battles, such as this developer would not accept a contract with a mortgage contingency clause, which essentially gives us an out, or your buyer an out if you have a problem with your mortgage. They will not take one. They are 90% sold, and they've done that without taking one contract that had a mortgage contingency clause. So again, the lawyers will tell you, well, you don't want to do this deal. You need some protection. So what I orchestrated with them was I said, okay, in their contract, they're giving you a 15-day rescission period, which they make a big deal of. They say, look, you have this 15-day out, so you don't need a mortgage contingency clause. Well, that's totally inaccurate. Number one, they're not giving you anything. Florida law gives you a 15-day rescission period. You've got it by statute. They're not doing you any favors. And that 15 days gets chewed up by every day they wouldn't give me their signature on the contract. So they know what they're doing. They've got smart lawyers on the other side. So I went back to them and I said, look, I'm not signing, I'm not going any farther if you do not double that 15-day period. I want a 30-day period with which to rescind this contract if you're not going to give me a mortgage contingency clause. And they heed and they hawed, and I said, look, this is a deal breaker for me. You won't give the one, I need this. I don't have it, I'm walking. And I did just that. I started to walk and then, no, okay, we'll give it to you. Okay, I want it in writing. No, you have our verbal commitment, we'll give you 30 days. And of course, I looked at them. I didn't have to speak to John or Mike to know that that was the craziest notion in the world. No, it has to be in writing. And so they ended up relenting and they gave me that 30-day rescission period. But then before they would sign, they start dropping addendums. Well, we want to change this. Well, we want to change that. And at that point, you're sort of at their mercy. They're sitting on your deposit. You still don't have an executed contract. You've got your mortgage people telling you, we cannot submit your mortgage until we have a signed executed contract, and that clock is ticking. So it's a real poker match. It's a real poker game, and you've got to decide what things you're going to stand on and what things you're willing to give up. But again, in representing a buyer, just make sure that you, in writing, give your client the options. Here's what your choices are. And if they choose to go against your advice to be able to get the deal done, at least you made them aware of it. So with that, I was essentially forced to sign a number of addendums, which entailed some risk. For example, if you look at the extensions, I got the rescission extension, but then they started manipulating the deposit. They manipulated the closing date. I had to sign that amendment. And then they hit me with this last one. This particular unit had a den in it, and that den was about the size of the master bedroom. And the developer, prior to me having any interest in this unit, built the den out. He put up a wall, a nice door. The door alone was probably $7,500. He built out the closet. And so he turned that den into a bedroom. So I get this addendum, which basically says that I agree that the plan that they're including in this addendum is what the unit looks like. And I said, okay, that makes sense. They're just updating the scale of this unit to reflect its present condition. And then you look at the very, very fine print, and in there they have buried that if I don't close, I will be responsible for tearing down the build out and bringing it back to its original condition. Now, I didn't say anything to the realtor. I said to the realtor, look, what's this clause all about? Oh, it just gives an accurate depiction of what the unit looks like now because they did that build out to the den. I said, okay. She doesn't say anything more. But if you look at that last clause in the smallest of print, it says that if I don't close this deal, I'm agreeing to tear the wall down, remove the door, remove the closet, and bring that unit back to its original condition, which makes absolutely no sense. I didn't ask them to do that addition. And if this deal doesn't close, number one, I don't know why they would want to tear that down. It adds value to the unit, but I'm responsible for tearing it down. Now, of course, John, Scott, you can't do this. Mike, Scott, you can't do this. I had to make a business decision. And that decision was, if I didn't sign it, the deal's over right there. And then I'm fighting to get my money back. Well, I'm a bit of a banker on gambling, and I'm gambling that this deal is going to close. So I signed it. But that's an example of how when you sign that contract and they will not sign it immediately and they've got your deposit, they've got you where they want you. With that said, we finally got through all of the addendums and all the issues, and they signed it. And the date between my signature on that contract and their signature is literally about 2 weeks. So 2 weeks of wrangling with them where they've got the gun at my forehead because they're sitting on my money because I had to play the deal the way they want it. Now, they made this particularly difficult for me, I think, for a number of reasons. First of which is I did beat them up really good on the price. Second of which is they're giving out a 7% commission on this. So of course, anytime you're going in on your own deal, you need to disclose immediately. I'm acting as my own realtor. And I did that, and that entitles me to a 7% commission. So in addition to that price of $110,000 less than their list price, I'm getting 7% commission on that deal, which is one more reason why I was not going to back out of this deal. I had them where I wanted on this unit. In addition, they're building a restaurant on the bottom floor. They're bringing in a company from London. It's called the Sexy Fish, which is a very high-end restaurant consistent with Zuma and some of those high-end restaurants. And my due diligence shows me that they're going to pump about $30 million into the build out. So once that goes into the bottom floor, I believe that this will be one of the few buildings in Brickell that's not going to lose money right out of the gate, because there's so many condos, there's so many buildings that essentially apartments are not holding their value extremely well. And I think this is going to be the exception to the rule. So what do you need to look for? You need to look for and understand you're using their contract. There's no flexibility. At least this developer wouldn't give me a mortgage contingency clause. So you got to look for other ways to protect your money, such as increasing the rescission clause in there. You have to remember that before they sign off on it, they're going to want your money in their pocket. And if you don't do it that way, your deal's over. And that once they have your money, don't be surprised if they start hitting you with these addendums that they want you to sign off on. And what I've done is I pretty much listed the major ones. If we can scroll up a little, Jennifer, I want to point out some other things that are important to look for in these contracts. Let's go to the $5,700 fee issue, and let's go to the developer's fee. So as I'm reading through the fine details of this contract, I come to realize, man, I really need every bit of this 7% because number one, look at number D. They have buried in there, and this print here obviously is enlarged, reimbursement to seller for utility, cable, and interactive communication deposits or hookup fees, et cetera, et cetera. Basically saying that they have advanced money prior to closing on this unit and that I have to pay them back for it. Well, look at the number, $5,700. Now, that's pretty significant. If you're not paying attention to this and you're not used to this, you're going to go in there and all of a sudden you're going to see a line on your closing statement where you're reimbursing communication deposits and hookup fees and impact fees on this particular unit, $5,700. So you got to pay attention to stuff like that. The developer's fee. Going into this, I knew of developers' fees. I had always heard they were about 1%, maybe 1.25%. I look in this contract and they have it at 1.75. And I was like, that's ridiculous. And I went back to them. I said, I'm not paying this developer's fee. They're like, we're not budging on it. And they're not. And then I went ahead and I spoke to my brother who represents developers. And I said, what the heck's with this developer's fee? Well, they're recovering certain costs and other of it is going into their pocket. But yes, that 1.75 is high. But I'll tell you right now, they're not bluffing. They will not budge on that. They stick with it. So you got to look for other ways to work that out. Keep an eye for those little details because they can add up. Finally, I said to myself, all right, 7% commission. I will use that money towards my closing costs. So I said, I want you to give me a credit at closing of my 7%. Nope, won't do it. If you want to take it as a credit at closing, we're only going to give you 5%. So essentially, to be able to use that commission money to close this deal, I got to take a hit of 2%. And as John so aptly pointed out, Scott, get the money somewhere else, float it until you get your commission check because you're walking away from 2 points on a big deal. You don't want to do that, rightfully so. And John, I thank you for that because I was contemplating, should I just eat the 2 points so I have this money to close with? No, in my situation, that was not the answer. But my point is, pay attention to something like that because they're scraping and clawing and scratching at every little thing they can. In the end, hopefully you'll get the deal done. Hopefully you'll be aware of these things so you can best protect your buyer. But I just wanted to make you all aware of it because I've just gone through it. It was a huge learning curve despite having closed a number of properties. And I just felt that you all should know about that. So if you're representing somebody that's buying from a developer, keep your eyes open for these issues. That's it.
Scott, I have a question.
Yes.
First, thank you for this amazing presentation. Wow, it's an eye-opener.
Thank you.
My question is this. You say that they signed 2 weeks after, and we know that with a contract, when the final signature date, this is when you're counting, let's say in your case, 30 days. So what happened in those, did they respect these 30 days from the final signature?
What happened was I started, at that point, I made a stink. I said, we are now 2 weeks past when I signed. You've hit me with 3 addendums. You've chewed up half of my 30-day, rescission period that I fought so hard to get. And in the end, we ended up re-signing a brand new contract. So they basically had us re-sign so that it didn't chew up all my time, but they didn't want to do that. They wanted us just to move forward and accept the fact that because they took 2 weeks, that was my problem. And I said, I can't do that. Primarily because I didn't have the mortgage contingency clause in there. And I needed that 30 days because I had it set up so that 30 days takes me right to my closing date. So God forbid something happens, I know at least the day before closing, if I have to bail out, I can. And they fought me tooth and nail on that, but I said, that is a deal breaker. That is something there's no flexibility on. Did that answer your question?
Yeah, thank you.
And I remain here. If anybody, if you get into one of these deals, don't hesitate. Please call me because it was a huge learning curve. It really was.
So basically 2 weeks later, they give you a new contract. Which means no
Yep.
matter what, you gain 2 weeks, and then what, they added 2 weeks or 30 days from that contract per your agreement?
No, then I had 30 days from that contract. They didn't want to do it, but I was fighting with them because they were playing these games. And I think the real thing for them is they want to get your deposit in their hand. So they're trying to figure out how to pry that money out of your hand the quickest before they're committed to anything. And then on the tail end, after we had this 2 week of going back and forth with these addendums and we're signing, you know, they were hoping, they were expecting that I would just continue forward. And I said, I can't do that because you've burned up half of my 30 days. And so then they issued a new contract dated for the present date. I signed off on it, and it still took them, here's a good point, it still took them 3 days to sign it. And that go round, what they did was, in the beginning of this, when I was dealing with the realtor, I called up a friend of mine who's a realtor, and I said, I want you to do me a favor. I want to play good cop, bad cop with this realtor because I've done my homework on her. And so that's exactly what they did. Even though I found the unit, I went to the unit and looked at it, and I started the negotiation process. I then brought in this other realtor who's a friend, told him we're going to play good cop, bad cop, meaning I'll be the tough guy, you be the nice guy. And then I turned to the realtor and I said, my buddy's going to help me with this. He's a realtor, but it's just to negotiate a little bit right now because I'm very busy with my law practice. And she said, fine. That back and forth got the price down to a good point. And then we walked away from the deal. And then we called her back 2 weeks later and said, you want to talk again? We got her back to the table. And that's how we eventually drove them down to the point where I think they regretted that they sold the unit, which in large part is why I think they made it so difficult, because they knew they were dealing with a lawyer. So it was like a game for them. And they weren't happy that they had come down to the price that they did, plus the commission. But, you know, it's sticky. It's sticky.
All right, guys. Anybody has another question for Scott? All right, Scott. Thank you very much for your presentation, you know, to share with
Thank
us
you.
the experience you had.
Now,
If
if
I
you have
could
any other
add to
questions, let me know.
Scott was doing. Scott did a great job, actually. A couple pointers that I want to have realtors also recognize is when dealing with developers, make sure, number one, do not send your client there without you. Make sure that you are, when you're dealing with them, go with your client and make sure you register with the client. There are a lot of sales agents there that are sharks, and if they see someone unrepresented, they're going to sign that person up and then you're going to be out of your commission. So it's important to make sure you accompany your buyer to any developer. Also, like Scott mentioned, you're going to be using their contracts. There's no question about that. However, some things can be negotiable. As Scott mentioned, they're going to fight you on everything, but it's not completely said and done. And if they're saying, look, we can't change the contract, as Scott rightly said, okay, well, we can put it in an addendum, and they're willing to do that. So it's not completely set in stone, but you're going to have to work a little bit harder at it than normal, but it can be, some things can be revised. Another point I want to make is definitely have your client, you have to make sure your client reads the entire contract. I know it's long. Some of these are purposely long. Developers do that on purpose, the attorneys, to try and wear out the buyers, but they have to read everything like Scott did and pick out especially parts where they talk about costs and fees, because they'll slip those in there, and at the closing date, we'll see this huge number on the buyer's side. We would say, well, where did this come from? And they'll point to it. Page 63, subsection 2, specifically says in there, buyer is responsible for this cost. So make sure buyer reads the entire contract. Also, if there is something that is changeable that the developer is willing to do, maybe a second parking space, maybe they're going to change the tile or the marble, make sure everything is in writing in an addendum. No emails, no phone calls. We have to have it in writing. And then finally, we have to use the developer's title company. Buyers cannot pick their own title company, but definitely recommend to your buyer that they hire their own attorney, like Scott did. Scott actually contacted 2 attorneys, which is smart. Make sure you tell the buyer that you highly recommend the buyer hire their own attorney to go over the contract and make sure they explain everything in the contract to the buyer. That's all.
Can I add one thing, Orlando?
Yes, I forgot to unmute my microphone.
One thing, Nathalie, I don't think I actually finished answering your question. What I was getting at was, so this individual had engaged in some of the discussions. So finally, after we had everything ironed out and we're signing this new contract, and I sign it and I'm waiting for their signature, they say, you know what? We want a letter from that other broker's realtor which says they're not claiming any piece of this commission. And we were like, why would they be claiming a piece? They had nothing to do with the deal. This was just a friend who happened to be a realtor who was speaking with you back and forth. But nonetheless, as John pointed out to me, well, it's wise on their part. They want to make sure that they don't have a battle over the commission later on. But nonetheless, they use that as an excuse to chew up another 3 days. So this was sort of like a big cat and mouse game with me. But hopefully I answered your question now, Nathalie.
I have another question. Were you protected? I missed like a little bit in the beginning. You bought this apartment on the paper, or they started already the development?
No, this building was built and completed. It was started in 2015. It was finished in 2019. And when I started this process, let's say 3 months ago, they were 90% sold. And then some of the original investors that bought units were already reselling them. I had looked at some other units that were for sale that were brand new, but it was not the developer selling them. It was just the investor that bought it pre-construction. But this building was finished in 2019, totally completed.
Okay, thank you.
All right, guys, another thing that we need to be also, I'm gonna reinforce a few things that Scott mentioned, is that if you're dealing with the developers, they don't have the loan contingency. And we know that the loan is gonna take at least 30 days. You're not gonna be able to close in 15 days. And they were gonna follow what is the states on the Florida Statute 475. And that's a reminder for us for new development and resales. The Florida Statute 475 states that the buyer has 15 days of rescission period to cancel any new development. And for the resale, it's 3 days. So after you receive the contract and the documents for the condominium, they have 3 days to cancel if it's a resale and 15 days to cancel if it's a new development. And you're gonna have to fight with the developer if your buyer is going to finance. Because if anything goes wrong and the buyer is denied on the loan, then they will lose the deposit, because that answer will come after 15 days and they won't have more time. The exit window is already closed. So that's something you need to remember and get at least 30 days. And another thing is very important is that being telling you all the time, is everything get it in writing. Don't accept any verbal communications, because you cannot prove that that agreement was done. So as Scott experienced, they agreed to him to give him 30 days, but they did not want to give him in writing. So, and he said, if you don't give me in writing, then I'll walk away from it. Right? So you got to remember all those things. Another situation is that Scott also faced is that there was some condition the developer imposed that Scott had to make a decision. He believed that if he didn't accept that condition from the developer, he would lose the deal, which in his opinion was a good deal, and he had to make a decision to accept it or not. and he decided to accept. But this is the thing. Scott is representing himself, so he's not going to blame him if anything goes wrong. But if you are representing a buyer and the developer makes a condition that you believe that that condition is risky to the buyer, and you bring that situation to the buyer, let's just revive what it is, what it was with Scott. They wanted him to be responsible to bring the dam back to the original stage. And it was ridiculous because Scott never asked them to build the dam. But he became responsible, if it doesn't close, to bring the dam back to the original state. He decided to accept it, even though he believes it's a risk for him. So if the same thing happens between you and a buyer, you're going to explain to the buyer in details what are the risks. If the buyer decides to make the same decision that the Scott made, which is, I will accept it, get it in writing, you know, put it in writing, all the risks, and get your buyer to sign, stating that you discussed with him that there was a risk by accepting that. Because if anything goes wrong in the future, we don't know how much they're going to charge to bring down the dam. It could be, I don't know, $10,000 to bring down the dam. You see that only the door itself for $700. So they might charge them $20,000 from
Hey,
a,
Lindo, that was
Yeah.
$7,500 just for the door.
just for the door. Yeah, $7,500 just for the door. Now the rest of the material, they use it to close the walls and labor to build and to bring it down. So it could come to a bill to $20,000 that your buyer is going to have to pay, and he may end up blaming you because you never told him, even though you did. So get it in writing. Get it in writing. And always remember, you see how many things this developer get it hiding inside the contract. So if you need help, we already know. John is here to help us. You get the contract, get your buyer, goes to John's office, sit down with John. John is going to read the contract and is going to explain your buyer all the details of the contract before they sign. That will be the best way to do it. Okay, don't try to read yourself, interpret, because two things can happen. Number one, you may misunderstand some things in the contract. Number two, you can be charged of interpreting a contract without the proper license. So we know that we cannot go beyond the scope of our license. And one of the things is that we can interpret a contract. Leave this to John to do it. Okay, and if you have any question, Scott is here with all the experience that he had to go through within this almost 4 weeks process, or even more than that. Hey, more, yes. And John also here to help us. Guys, you have any questions related to this topic? Good. Good.
Arlindo?
Yes.
Hi.
Hi, Marty. How are you?
Fine. How are you?
Thank you for being here with us.
Oh, my pleasure. Thank you. I wanted to, as a lender, kind of add a little bit on the builder
Of course, yes.
arena, if
Please.
you don't mind.
No, never.
There was a time that all I did was focus on builders. And so it was a really great experience. Now, there is one particular builder I've worked with for the last 10 years, and they work a little differently. They definitely have mortgage contingencies. Most builders have mortgage contingencies in their contract, and it's really very big risk when you don't have that. Definitely. Scott makes great points, and John. Now, if I recall correctly, in Miami, when I was working with a builder, I believe that the builder fee of 1 3/4 actually covers the deed stamps and title. Like, it actually covers certain closing costs within it. Is that correct, Scott?
I'd have to defer on John. I don't know what comprised that 1.75. I was just told some of it are hard costs, and
Right.
there's some of it that's sort of reimbursement for advertising and marketing they do, but I would really need to defer to John. I don't know specifically.
The answer is yes. it's a large sum, so they use a lot of that money, like Scott said, to do some of the work toward the association, but definitely toward closing costs for sure.
Oh, that would have been charged probably in most cases, even if it was a resale. The other thing is, typically with the builders, they have an approved lender list if they, if they do have mortgage contingencies. I've had the, pleasure of being on that approved lender list many times for builders. And it is very advantageous to, maybe not Scott's builder, but in general, there are advantages to working with an approved lender on the lender list, because like the builder I work with, I'm an approved lender. And so the client gets $7,500 toward closing costs if they work with me, or one of the other approved lenders on the list. So that's something to keep in mind as well. But so if you're ever working with new construction and, you need a lender that understands that and working with builders, I'll be more than happy to assist as well.
Great, Lori. Thank you. Thank you for your input. Yes, guys, we have the in-house lender work with us. It's our partner, which is Loan Depot, being represented here by Lori, very well represented. And if you guys have any questions, you have Lori contact number in our group chat, because she is in our group chat. You just look for her name and give her a call and ask all the questions related to loan that you may have. Okay? Great.
Thank you.
So we do have 10 minutes left in our meeting, and I'm going to try to show you something that I've been trying to do since our last meeting. We spoke about it, how we would control our transactions in terms of not missing any documents, and most important, not missing any dates. Okay? And John has a hard copy of a Word document that he created that you guys can use it. You just print that out, and then you put it on your file for that transaction, and you follow up in writing. Anything that happens, you put on that piece of paper. Or you can use Trello. Trello is a very simple application to use and very good. I've been working with the Trello for a while with my assistant. She was the one who started using it, and then every time that I give her a transaction, she puts that transaction in Trello and shares that with me, so I know what she's doing and I have all the follow-ups here. You guys can search for Trello and create your account. They do have a free account, but unfortunately, your first account, you're gonna have to provide your credit card, and then you downgrade it to the free account. So when you downgrade to the free account, you have all the privileges. You just can have a group of people work with you, like a large group of people working with you in the same transaction, which is not the case anyway. So the free version will suit you guys, all of you. And once you have, I can share these templates. I created here a template, as you guys can see here. Let me get my notes here so I can point that out. As you guys can see here on the name, it's a template. Okay, so I use these templates to create my my transactions. Okay, I just go here, show menu. The show menu, I go more, and I copy board. When I copy the board, then I can change the name. So then it will be my transactions, and I will have all of these in my new transaction, and I can share that with you. Now let's look into the details so you guys will see how this will be helpful to you. On my first column here that we call list, it's a one list here, another listing, another listing, and another listing. I have all the documents that I need in a transaction. I need the MLS to be part of my transactions. and I need the pre-qualification letter and proof of funds if it's a cash deal. I need the sales contract. She works for 3 different brokerage, and then she put the notes here for each brokerage, the broker fee that they charge. Kai's charge $6.95, Keller Williams charge $4.95, and we charge $3.70. Inspection disclosure. We learned that if we're representing a buyer, either or, if the buyer wants to do an inspection or not, it is good to have the buyer to sign the inspection disclosure to hold you harmless for anything that shows up on the disclosure. So by looking to all the list of documents, you're not gonna miss any document. You know, you have the condo writer. If you're preparing a contract, you're thinking, what are the documents missing? And you also have the lead paint, if the house or the property is built prior to 1978. And FIPTA, if the seller is a foreigner. So all the documents is here. Pets, do they accept pets? Yes or no? And every time that you have the document, you can bring that to done. You remove them from this column here, and you move to done. Example, the MLS. Do I have the MLS? Yes. So I click here on the MLS, and I drag the MLS to done. Now I know I already have this. Okay? So you can see how helpful this thing is. Now, sales contract. Do I have the sales contract signed? Yes. So then I click on the sales contract, and I bring the sales contract to done. And every time that I have one document, disclosure, was it signed? Yes. Then I bring them to done. Okay? Now, the most important is the follow-up with dates. You don't want to miss that. So I already create the inspection, the loan commitment, the first deposit, second deposit, appraisal, and closing date. So because this is a template, I can come here to inspection, and I will put the date. Let's say the date will be in February 2nd, 2020. Let me put better. Let me put on the 8th of 2021. Okay, now I have the date for the inspection, and this is what I'm gonna do. I'm gonna put a label here in red. So every time that I look here, whatever is in red is missing, and I need to look at the date. It's coming close, and I don't have it. The closing date is going to be, example, in March 1st, 2021. Oh, sorry, 22. So then I'll come here, and I will add the label and put red. So I'll be looking, it's coming close to the closing date, and I'm not ready yet. If I'm ready, then I can change the label and put it in yellow. And I can remove the red. If the inspection is done and I'm okay with that, then I will change the label to green, and I'll remove the red. So every process you are following up online, and it's very simple. And you don't have to type anything because I already create the templates, okay? The website is trello.com. Then you create your account. And I will invite you, or I will copy this. Actually, I have to invite. I will invite you to this, and then you make a copy of these boards to yourself, and then you change the name of the board. It's just very simple. You see the name of the board here. And I will change it to the transaction. 270, 210, 174 Street, Unit 1106. Now I know that this transaction is related to this unit here. And then I can make a copy of this and create it to a different one. And then keep on going on and on and on. And every time that I have a new transaction, and I use that. Guys, I really believe that this is very helpful. And if you guys don't want to miss any dates, this is one of the best software for you to use. Of course, if you want to do manually, you can have a form that John created on Word, and then you follow up, and then you make the notes on that form, and then every time you go and look at the form, and if anything changes, you make a notes on this form, so you don't miss any dates. I had a conversation with one of our agents yesterday about the fact that his buyer is still not ready to close, and the close is supposed to happen tomorrow. Luckily, of course, he's been on top of the dates, and he called me about what to do if the seller doesn't want to give an extension. And then we were having a conversation about that. So dates are very important, as we mentioned before in our meetings before, and you don't want to miss a date, come to the inspection, and then the buyer did not do the inspection, and now the buyer receives the inspection report, and based on the report, the buyer decides not to proceed with the purchase. But now, because he did the inspection after the inspection period, the window is closed. Now he cannot walk away from the contract anymore. So that's why all those dates are very important. You need to follow up with that, and this is going to help you. Scott, what do you think about this, Scott?
I was actually just talking to my assistant about that because we've been doing this for my deal by hand. So every couple days I sit down with her and I say, okay, and we go through our punch list, check off what we've done. We have warning dates of when we're getting close to a deadline, but this essentially can make it a whole lot easier.
A whole lot easier. And this is the thing, Scott, you can invite, and I'm going to do this with you, okay? I can invite you, and we are going to be looking to the same transaction, meaning what I do, you see on your computer, and what you do, I see on my computer.
Okay.
This makes your job with Jennifer a lot easier because you don't have to sit down with her to go over all the items on the transaction. She just make the change, and then you look on your computer.
That's
Give
great.
me your email, the email that you can open now.
Let's see, email. Well, I'm going to go to my phone for that. So you're sending me an email now?
Yes.
Nothing yet. You sent
No,
it?
no. What is the email? Tell me your
Mine? You want me to plug it in?
Yeah, no. You tell me and I will type it.
All right, Scott, SCOTT, @ then my last name, Kotler, KOTLER, dot, and then the word legal, LEGAL. That's it.
All right. Send the invitation. So now you got in your email with a link. So when you click on the link, it's going to open exactly what we have here. And if you make a change, I'll see here.
Gotcha. All right, just came through. Got it.
Mm-hmm.
Now I'm switching over. Hey there, Arlindo Machado invited you to join. And then you've got this address here. I'm working on this project. Now I've clicked on the box. It's taking me somewhere. It's loading. Oh, I got it. Here I am.
All right, good. Now do me a favor. You see the first one on contract says pre-qualification letter. Do you see that on the left?
Yes.
Now click and drag it to done.
Click, drag it. Oh, card not found. Huh. All right, let's try it again. Click. It's not letting me drag.
You keep holding your click, right?
Hold on, let me get my right hand here. We got to click and drag.
Yeah.
Hold
the click.
Yeah, see, it's because I'm on my laptop, it's not dragging.
No.
Oh, but you're going to have to hold the click. You click, hold, and then you drag with the other hand. It's okay. You can do that too.
Oh.
I have Jennifer working on this. She's my guru. We're having a hard time here. It's not dragging.
No.
All right. No problem. You might have an issue with your mouse, but let me tell you one thing. I'm going to do that, and then you're going to tell me if it moved. Okay, I'm
Okay.
gonna get my pre-qualification letter. As everybody can see, I'm moving to done.
Yep, it moved.
He moved. You see what I do, you see, and what you do there, I can see here. So you can work with your partner, your assistants, with whoever. And this is an amazing software, guys. And I have already the templates done, and I can send it to all of you. And as you can see here, let me show you this. I'm gonna make a circle here. As you can see here, before I have only myself, AM, Orlindo Machado. Now I have S, which is Scott. And if I invite another person, I will have 3 circles here showing me who is sharing the same board.
Oh, wait a second.
Okay?
No.
Now, if you guys have any questions about this, I'm gonna have this, of course, in our website. I'm preparing all the videos to put it there so you guys can go back and then watch it again. And if you have any questions, give me a call. Orlindo, I like this software and I want to use it. All right, give me a call if you can make it happen, or if you want the templates to be sent it to you. So I'll send the templates to you. All right, guys, you have any questions about this?
No, it looks like a good tool. I can use it.
Good, great, great. I'm happy for that. All right, guys, we are going to be seeing you guys again. I want to thank you, Scott, one more time for being here with us and sharing your information. John, thank you for being here with us. You've been a great partner in our business, both of you guys, and also Laurie. Thank you for being with us here and sharing also your knowledge with us. We will continue preparing meetings and subjects that will help you guys to grow your business. And the most important thing is make money. All right, guys, enjoy the rest of your day. Yes, go ahead, Scott.
One word we may want to throw out to our realtors is to remember that while the mortgage guru with us and the real estate guru with us are helping us, we also want to help them. So any chance we have to bring them into our deals, I think we need to try to do that. And use them and bring them business as much as possible. I had committed to my mortgage stuff probably over a year ago. I've been working with somebody, but moving forward, we need to remember who's working with us and try to help them as much as they're helping us.
Very good point, Scott. Thank you very much. That's very true. John, I have no words to describe the job that John has done for us and how much help he's giving to the company and to all the agents. And it's only fair that we give back to him by bringing all the deals for him to close. And the same thing to Lori. Lori is being pressed in every single meeting, and she's always bringing some important information. And it's only fair to bring our buyers to Lori so she can work with them to help them to get a loan and close the deal. But let me tell you one thing very important, and Scott pointed that out very well. It's not just to pay it back. They are very good professionals in the area. They're very good professional. John knows a lot about the real estate law, the closing, the title search, and he does it very professionally, and his fees are very reasonable fees. So it's not just a payback. He deserves, as a professional that he is, to get our business. And the same way to Lori. She deserves to get our business because she's very knowledgeable, she's very professional, and she will be able to help our buyers to get a loan and close our deals. Great, guys.
Yeah. That's very sweet. It's actually a great team and a testament to you putting this team together. You know, we work with other real estate companies and brokerages, and no one sets up teams like this like you. And also, you are the only broker in this area that I know that does a monthly meeting to educate the students and keep them informed. And you're there to help. So it's a privilege to be friends with everyone here at the company, and a privilege to be your friend and Scott's and Lori's as well.
Thank you, John. Appreciate that.
Thank you.
Thank you. All right, guys. With no further information, we'll meet again in 1 week. I wish you guys a very good rest of your day. Enjoy it, and a great weekend, and I see you guys next week. If you need me between them, give me a call. Thank you.
Thank you, Orlando, for everything. Thank you, Scott. Thank you, John.
Thank you.
Bye, guys.
Thank you. Bye-bye. Thank you.
Be safe.